So while we're waiting for that, it's worth me saying this before we begin. You know, we went through these motions to dismiss, and I never actually brought this up, and it's worth doing before we start a trial. I'd like to give the parties one last opportunity, if they wish, to see if a settlement can be reached. I don't know if the parties have had a chance to really have much of a discussion other than the initial mediation. But I always encourage parties to take one more shot at it before trial. And the reason is this, and Mr. Carney, I know you know this, but it's worth saying. At a trial, I will resolve the issue one way or the other. But invariably, at least one party walks away unsatisfied with the result, right? It's an all or nothing deal often. Sometimes, shockingly often, both parties walk away unhappy with the result. A settlement is not a win. A settlement is an outcome that both sides can live with, where you control what the result's going to be. I have no idea what's going to happen. I don't know what the evidence is going to be. I don't know how it's going to relate to the law in this case. So I can't tell you what the outcome of a trial is going to be, but I can still give you control over the outcome if you want to talk about a settlement agreement. So let me start with Mr. Carney. Are you authorized to negotiate a settlement?
I don't have any authority at this point. I mean, maybe when Mr. Zorbalis pops on the line, we can.
Okay. So when your client arrives, we'll ask
him.
Ms. Maville, would you like to try to negotiate a settlement with him when he gets on the line with us?
I would.
Okay. All right. So let's do that if the plaintiff is willing.
Hey, can you pop on the line? Yeah, on Zoom, 9:30. So. Okay. Yeah, maybe you just popped in the waiting room. Okay. He'll log on again. Thank you.
Yeah, he's not in the waiting room.
Okay. Yeah, he said that he tried a couple times. I don't know. He's not technologically savvy. So.
Well, neither am I. This has been a journey.
Yeah.
Your Honor, I'd like to bring up one thing, and that is I just got submitted from Mr. Carney a bill for painting or something with the apartment, and I have pictures of the apartment, but I thought they were in my file, and they were e-filed because I filed them right from the original when I put my claim in, which was going to be in person.
Okay.
When I went to the courts and filed it. So they were submitted, but I'm told by my daughter, who's been doing all my technical work, that they're not, she doesn't think they're in there. Pictures of the apartment.
Yeah, the ones that you submitted to the court, Ms. Maville, are included in your original statement of claims. They've been the very first document that you filed is where those are at.
So the pictures are in there?
So yeah, so if you go to your statement of claim, your original one, you have 1, 2, 3 pictures that are, they show.
Okay, well those, those were taken when I moved out.
All right, so I'm going to do something. I'm going to get a little technological here. Okay.
Okay.
It's called a share screen. All right, so you can see what I'm looking at. There you go. So here's the thing. Now, I don't know if these pictures were originally color pictures that you submitted, but the clerks only scan in black and white.
Oh, yeah. I believe they were colored, but you can still see the walls are not damaged.
Well, we'll get to that. I just want to make sure that these are sufficient quality for your purposes today.
Okay.
Are they?
I believe so.
Okay. All right. Well, there we go.
Okay.
All right. So it says Spiros Zormpilas has joined the meeting, but he's not showing up in my list of people that I can allow in. I'm not sure what he signed in for. Hold on, let me. He's clearly trying to.
Are Zoom or are small claims going to continue on Zoom?
We are in discussions about that. The AO from the Supreme Court indicates that we are to try to find places where we can remain. He tried to sign in for the June 9th one.
Well, at least he knows how to get there. So maybe if he just re-signs in.
Yeah, he's using the wrong invite. He's trying to sign in for the June 9th invite.
Send him the new one again.
I know some of the judges use the same login ID and password every time. I didn't do that because this is the possibility of Zoom bombing. We had some issues with that at the beginning.
I find the Zoom is pretty difficult because, you know, live court, you have your papers in front of you, you can present them. This is really hard if you're not technical at all, which I'm halfway.
I couldn't agree with you more. So like I said, the Supreme Court of Florida is really reopening the doors to everything on June 21st.
Yeah, it'd be much easier, I think.
We are still going to have some proceedings that remain remote. They're encouraging us to do that, mostly for sake of resources. We have a pretty big.
I know you used the one prior. The new one is 994.
Hold on.
Yeah, so it's 994 4605.
Mr. Carney, I'm going to go ahead and mute you for just a moment, okay? Oh, there we go. All right. So anyway, as I was saying, you know, there's a bit of a backlog in certain areas of the courts.
Mm-hmm.
And so as a matter of just being able to have space to use to deal with those backlogs,
Right.
prioritize that. So some matters are going to stay remote for a while. But things like this non-jury trial, at least the county judges in Collier County are pushing to have these in person for that very reason. It's just easier for a lot of people, myself included, to have human beings in a courtroom with their pieces of paper.
Correct.
It's very old-fashioned, but it works.
I know, submitting all that, it's been a journey for me and a lot of work, but I appreciate your assistance and your Sarah's assistant. That's been very, she's wonderful. She's been very helpful and very nice and made me feel,
I mean, obviously we can't help you with your case, but we can help you with the technical side of making things work so you can get in front of me.
Exactly. And she gave me a lot of good information.
All right. And it's funny, you know, now we kind of got things figured out how to do this. We're going right back into the courtroom.
Okay, Your Honor, I got in. I've been trying to get in for 10 minutes and it wouldn't let me in.
I believe you. You were using an old invite for a different date.
I see, and every time it was kicking me out, it was saying, wait for host, wait for host, wait for host. And it would never let me in. I'm sorry.
Okay. No, you're good. You're good.
I apologize.
No problem, sir. This was the only case set for this docket. I don't have anything scheduled till 11, so we've got time. All right. So, Mr. Dornpalas, you did, however, just mute yourself. So go ahead and turn your mic back on.
Go ahead, sir.
All right. So what I was discussing with Mr. Carney and Ms. Maville before you join in, nope, you're muted again.
It keeps muting me. I don't know why. I don't do anything, and then I got a thing saying stay unmuted. It was kept muting me because I'm not the controller. Okay. Can you hear me?
I can hear you.
Okay. Sorry, I'm trying.
It's okay. So as I was saying, I was inviting Mr. Carney and Ms. Maville to attempt one more time to see if a settlement can be reached. And as I was explaining, Mr. Carney informed me that he does not have authority at this point to engage in settlement negotiations. He needed to have his client present. Now you're here.
Okay. So it's just the three of us, Your Honor?
Yes, sir.
Okay.
If what I was saying was, I'm here to resolve your case today, one way or another. We can have a trial. At a trial, I guarantee that at least one party will not be happy with the result. Sometimes both parties are unhappy with the result.
Got it.
Whereas a settlement is a guaranteed outcome that you know you can live with.
No, I understand that, Your Honor. We did the work. The issue is we did the work.
Hold on. I'm not getting into that.
That's for trial.
Okay.
Not just yet. That part's for trial. My question is, would you like to have a moment to speak privately with your attorney and Ms. Maville and see if an agreement can be reached?
I mean, we never try to get to this point, Your Honor. We have email correspondences from my manager to her. We tried to resolve it.
Spiros, do you want to settle or not? Do you want to have discussions with Ms. Maville with just us three or not? Yes or no?
I'll take a moment. We owe her the $70. She never returned the form for her check. Well,
All
give
right.
her that. I mean, I'll listen to her for a second. It doesn't hurt, but
Okay.
I mean, we do our job, and here we are. I'm very
That
frustrated.
would be great, Your Honor, if we could
All
just
right,
have
let's-
like a moment with,
No, I withdraw. I don't want to have a discussion with Mr. Zarzabellis or however.
sounds like we're ready for trial, Judge.
Yeah,
Then we're gonna have a trial. All right, then here's how this works. So Ms. McVeal, you get to go first because you are the plaintiff, okay?
okay,
You can present any testimony you wish or documents. The documents have been submitted electronically, so you're gonna have to refer them to me as we go through it. If they've been filed in the court file, I can address them. I'll pull them up with the screen share like we saw before.
okay,
I'm going to turn to Mr. Carney and ask if he has any objections to the documents. His objections are gonna be based on the rules of evidence. And then I'll make a ruling based upon any objections he might have. If there are no objections, I will mark them. I'll print them out here, mark them, and submit them to the clerk. Okay. When you're done speaking, because I don't see that you have any witnesses or anybody else with you, Mr. Carney may ask you some questions. Okay.
okay.
When that part's done, it'll be Mr. Carney's opportunity to present the defense, and I can give you an opportunity for a brief rebuttal. All right.
Okay.
Do you have any questions for me before we begin on just how this works?
No, I do not.
All right. Mr. Carney, were you going to call Mr. Zornpalas as a witness?
I was planning on it, yes, Your Honor.
All right. Sir, are you able to turn a camera on?
Okay, Your Honor.
Sir, if you're using the space bar to mute or unmute, if that's what you're doing, that only does temporarily. You have to actually click on the thing to unmute it. There
Do
you
I
go.
have to hit this? Do I have to hit the start video below? I'm looking at it. Is that what you
Yes,
need
sir.
me to do?
Yep, click on
Okay.
that if you have a camera on your computer.
I want
Okay,
to see your
let me
pretty
go.
face, Mr. Zorbalis.
Okay, let me go right there. Do that first.
Yep, there we go. All right,
There we
I
go.
can see you. All right. All right, so here's what I'm going to do. Mr. Carney was going to call you as a witness, so I'm going to ask both Ms. Mavil and Mr. Zornpalas to please raise your right hand. Solemnly swear or affirm that the testimony you shall give will be the truth, the whole truth, and nothing but the truth.
Yes.
I do.
All right, please put your hands down. Ms. Mavil, let's start at the beginning. Give me
Okay.
sort of a brief summary as to how we got here and why you think you're entitled to the money being sought.
Okay, which is my deposit for $1,200, which I submitted via money order to Real Estate Development Group. So, and why I put Real Estate Development Group and Mr. Zardell. I'm sorry, I can't say his name properly. How is it? Zordelis?
Zorbalis.
Zarbalis.
Zorbalis.
Mr. Zarbalis. Because he is the principal of that company. So that's where I submitted my claim for my deposit. I hired a handyman to come in, and I only hung 3 pictures and removed those nails, and he filled them. And in his statement, he says how he did it. He's a professional handyman. He's always worked for me. So I hired him to fill in my holes. The apartment was left in better condition than when I moved in. When I moved in, there was grout all over the bathroom. I had to hire him to come in and take the grout out. Different things. I was not pleased when I first moved in. I had to fix up the apartment, the condo. Anyway, in any case, it was left in proper condition. My handyman said that. The people that helped me move out, there was no damage to the walls. It did not need to be repainted. If he felt that he should repaint the apartment, I don't understand why my deposit would have to pay for painting the apartment. And $1,300. That's just, there's nowhere in the lease that it says that. I left it in the same condition, if not better, than when I moved in, because I had my handyman make sure that it was in good condition. And that's why I took the pictures. And actually, Mr. Zarbella's secretary, Rosaria, told me, make sure you take pictures moving in and moving out. So obviously, this isn't the first time situations like this have come up. All I can say is I did what I was supposed to do as a tenant. I left the condo in decent condition, in there was just normal wear and tear, even above normal wear and tear, and that's my statement. So I got a statement saying that there was this and that, and that's why I did not send the letter back saying the $70 would be returned. There is no need to, and even if he did felt like he wanted to repaint the apartment, which sometimes landlords do after 10 years or 5 years of wear and tear, that's fine. But it had nothing to do with my time that I was in there leasing the apartment. The walls were in good condition.
All right. Did you ever receive a notice of intent to take funds from the deposit for repairs or anything like that?
No.
Okay.
The only thing I received was saying that it had been done and that they were going to charge me, and that I had $70 coming back to me out of my $1,200.
Okay.
But that was after it was done. And then I asked for proof of the damage because there was no damage. Like I said, I had my handyman as a witness, and it just baffles me. And I had very poor communication with the Office of Real Estate Development Group, which is who I dealt with from day one to the finish.
Okay.
And, all I got in my reply asking for proof and why did they have to paint the condo was, we're done here. And I have that email. I don't know if I submitted that or not, but.
Well, like I said, now things that you have filed are not yet evidence. So tell me what document it is you want me to look at right now. What did you submit that you want me to consider?
Well, I can't remember what I submitted in the beginning, except for the pictures. I think I submitted some of the emails and correspondence going back and forth. I'm not really sure because it's been 2 years.
Well, can you tell me which email it is you want me to look at? Because I can't help you, but you can tell me what it is
Okay.
that you filed that you want me to see.
It's the email where I asked that I said said that it didn't need to be painted, and can they show me where the proof was for damage to the walls, and then the reply email. So I don't know if that is in there. His reply was, "We're done here," and that's when I went and filed my claim.
Okay,
So that would probably
let me
be
do this.
in October.
Let me show you what was filed with the complaint, and you can tell me which one you're referring to. And then, Mr. Carney, obviously, I won't read it until you have an opportunity to raise an objection. So here's one page I've got.
Okay. Right.
Is that it?
Let me see.
This one is from December 10th of 19.
Right. And I believe that's when yeah.
This one's from December.
So,
10th of 19?
I am not set, but I'm not sure. There was another email. So this is not the one. There was another email that was sent back after, I think it's after this where.
This one's another one, Friday, December 13th of 19. And here's another one, Friday, December 13th of 19. So this is going back on the 13th of December of 2019. And once again, Mr. Turner, I'm not considering the content of any of these yet.
Mm-hmm.
You're going to have to tell me if this is something that you want me
that I want to submit.
Yes, yeah. You have to let me know that you filed these, but they're not evidence yet until you ask me to consider it as evidence. Do you want me to go to the next page?
Yes.
This one's a December 10th email.
Mm-hmm. Yeah, I would like this submitted because this is where I'm saying that I did take the pictures before and after.
So you're talking about on this Tuesday, December 10th, 2019 at 1:25 p.m. This one.
Yes.
Mr. Carney, any objections?
Judge, I'll object to that one, but if you just want to submit or enter into evidence the whole email thread that she sent, I won't have an objection to that.
Then let's do that. That'll be easier. All right. So what was attached to the complaint, pages 4, 5, and 6, will be admitted as plaintiff's composite 1, and that way just the whole email chain will be in there. All right, so now I can read it. All right. Okay. All right, ma'am, was there anything else that you wanted me to enter?
The letter from my handyman, John.
All right, so one moment. Where is that? Was that something that was filed as an exhibit?
It was the second exhibit, Judge.
The one from June 2nd?
I believe so,
Yeah.
yes.
All right, let me go ahead and do the screen share again so Mr. Carney can see it. So let's see, this is an email. John Sokor, is that it?
Yes.
All right.
No objection to that one either, Judge.
All right, that'll be admitted as plaintiffs 2. Let me read it. Not removed now, is it? Okay. All right. Anything else, ma'am?
Did I file anything else? I filed that.
You did.
Oh, my checks paying to Real Estate Development Group and the check for the deposit, the copy of the amount of the deposit and first month's rent.
All right. Is that
Right. That was one of them. I think I copied 3 of them.
I have no objection to the first 2, Judge. I'll object to the third one.
this one right here?
Yeah, I'll object to that one.
What's your objection?
I have no idea. It's all handwritten. It's 2005-32-35. I don't think the proper foundation has been laid to admit it.
All right, this isn't a check.
It's not a check, it's a withdrawal. I don't know.
No,
if
it's a show,
or-
but it has who it's made out to, Real Estate Development Group. That was the deposit and the first month's rent, which was, I didn't move in until October 5th, so it wasn't, that's what those 2 amounts are, so. And it says Real Estate Development Group on it, handwritten. That was what the bank wrote. It's from Chase. It's from my account. I don't know.
I'll renew my objection on that, Judge. I don't think the proper foundation has been laid to admit.
I agree. All right, so the first two, the two checks will be entered as plaintiff's composite 3. All right, and it appears to be everything, ma'am, that was filed. Was there anything else? Any other evidence that you intended to introduce today?
I think I'm pretty sure that's all of it. I just wanted to prove that I only dealt with Real Estate Development Group, and so that was the reason for the checks, and then my letters and my pictures, which that's all the proof I got.
Okay.
And my letter from my handyman.
Okay.
So
Well, the pictures were not entered as evidence.
we're not entered?
No.
Or can they be entered as evidence?
Well, let me ask Mr. Carney if there's any objection.
I'll object to foundation.
Okay. So what that objection means, ma'am, is that you haven't explained why those pictures are relevant and what they are pictures of, and what will they show me in this case?
I haven't explained that? Is that what you said? I'm sorry.
Right. You need to explain to me why those pictures should be admitted in this case.
Because they were pictures of after I moved out and of the conditions of the walls. I was told, I told you, I think I stated from Mr. Zarbella's secretary to take pictures when I move out and when I move in, which is what I did. So those were pictures of when I moved out, and that was that, to just show that the walls were clear. There was no damage. I don't know where you can see there's no damage to the walls. There's no holes in the walls. And so that's my evidence. And I was told to submit those and to have those.
Okay. Mr. Carney, are you
Same
ready?
objection, Judge.
All right. The objections are ruled. The 3 pictures will be admitted as plaintiff's composite 4. Six. All right. Is there anything else, ma'am?
Composite 4, the pictures.
What's that?
The pictures were composite 4.
Composite 4. Yep.
Thank you.
I think that's it. That's just it in black and white. I don't know what anything else that I need to have.
All right.
I hope I don't.
Is it a fair summary of your position then that you gave Real Estate Development Group $1,200 for a security deposit? You feel that they improperly withdrew that money for painting of the walls, and you feel you're entitled to your money back. Is that a fair summary?
That is.
All right. Mr. Carney, do you have any questions for Ms. Maville, or would you like to call your first witness?
Yeah, I do. Ms. Maville, you entered into a lease agreement on October 4th, 2018 with Reserve at Naples Condos LLC, correct?
Yes, that's what the lease says.
Thank you. Do you admit that entering into that lease with?
I entered into that lease with Real Estate Development Group. The Reserves of Naples, no, I don't, even though my signature is on there, I was told to make all my checks out to only deal with Real Estate Development Group. But if you look, they are of the same. Mr. Zarbella's is principal on both companies, so I don't know why they were playing the shell game and I was going from here to there.
I understand that, Ms. Maville. I'm just asking if you entered into a lease.
I entered into the lease, of course, the lease is there, my signature's on it. I didn't realize that it was a different.
Do you have any
company.
objection to the court entering in that lease into evidence?
Well, no, because my name is on that lease and so is Mr. Zarbella's. So no, I do not.
Yeah, I'll move to admit that as defense exhibit 1.
That was filed, Mr. Carney.
Correct. In the
Your
motion,
original motion to dismiss.
correct. In both of them, Your Honor.
Okay, let me pull that up here.
This whole paperless thing is tough.
What's that?
The whole paperless thing when you're on computers and
We are going back into the.
Tell me about it.
People will show up with a stack of papers and they can hand me something and say, "Hey, Judge, look at this." It's going to be great.
I'm looking
Yes.
forward to it as well.
It's a lot of work for the judge and the attorney. And for me, I'm just lost. I've been lost since day one.
Well, we're getting there. We're so close. All right, hold on. My computer decided to take a little nap. Give me just a moment.
Oh, no.
This will take just a moment. I've got it. All right. So let me print this out because it's about pages 5 through 20.
All right.
And I got to tell you, I have never in my entire life had a piece of paper suddenly crash and stop functioning. They're saying maybe low tech, but it works.
Yes, it does.
All right. All right.
Go
It's
back to the
printing
old
now.
days.
All right. Yep. It's printing now, Mr. Carney. Please proceed.
Thank you. And on page 1 of that lease agreement, Ms. McVeal, it states that lessee shall make a security deposit with rental agent upon execution of this lease in the sum of $1,195. Is that correct?
I believe so, yes.
Okay, so it's not $1,200 that you're seeking, correct? You're seeking the return of the security deposit of $1,195, correct?
If that's what it says on there, I thought it was $1,200, but if it says 1,900, that's fine.
Okay, and you agree that both the checks that were entered into evidence as Plaintiff's Exhibit 3 were made out to RDG in the amount of $1,195. Is that correct?
That's right.
Okay, so you wouldn't dispute the Reserve and Naples Condos LLC that they're holding a security deposit that would have totaled $1,195, correct?
Say that again, please.
Do you agree that the security deposit is only $1,195 under the lease agreement?
Yes.
Okay, so now we're there. So if you go to page 8 of the lease agreement, it says that there's an administrative processing fee. The lessee will pay an administrative processing fee of $195 the last month before vacating. It will be due on the first day of the last month before vacating. It will automatically be added to the lessee's ledger. This fee will be applied towards processing, coordinating the move out, inspections, walkthroughs, security deposit return administration, and paperwork, and will compensate management for any of the administrative reporting and compliance. Do you agree that that's what the lease says?
That's what, yes, I do.
Do you
But
agree that
that's
you
not
owe
what they did.
Do you agree that you owe the $195 administrative processing fee?
Yes.
Okay.
Along with the $250, which I already paid, the $250 cleaning fee.
Yeah, I'm just asking about the $195
All right,
processing
fine.
though. So
Yeah,
okay.
I think I already paid that, but okay.
If we go back to Your Honor, bring court's attention to the original statement of claim, the second page, it says notice of intention to impose claim on security deposit.
I'm sorry, what are we looking at now?
The original statement of claim that Ms. McVeal filed, and if we go to the second page, it says notice of intention to impose claim on security deposit.
All right. Just a moment here. Oh, okay, there it is.
So Ms. McVeal, if you go to the original statement of claim, it says notice of intention to impose claim on security deposit, and you filed that with your original statement. Yep.
Were you going to move this into evidence?
Yeah, I was going to ask her about it, and then I was going to move it into evidence.
All right, go ahead.
Thanks. Do you agree that you received that document?
I don't see that document. I'd have to see it. Can you put it on the screen?
I can.
Oh, okay.
There it is.
Thank you, Your Honor.
No problem.
Because you had previously testified that that you never received a document,
Sorry, here it is.
Stating that notice of intention to impose claims. So this is the document that you filed, Ms. Maville, in your original statement of claim. Do you agree that you filed that in your original statement of claim?
If I agreed, I didn't know what 100, see, there's the $125. Did I file this? Is that what you're asking me?
I'm asking you, yes.
I must have, let me see. Is that the total? I only see the top part. I don't see the bottom part.
I can scroll down.
Yeah, thank you, Judge.
And this was the notice that I got from Real Estate Development Group. Is that what you're saying?
That's correct.
Yes. And
Yes.
I filed this.
And it's titled Notice of Intention to Impose a Claim on Security Deposit.
Okay.
Okay. And if you
And
look
I
down
did
there,
this. Mhm.
and if you look down at the bottom, it says administrative fee under contract, $195. That was deducted. Correct?
Okay. Yes.
Okay. So just based on that, would you agree that the maximum amount that you'd possibly be owed out of that security deposit would be $1,000? Would you agree?
Yes, I would agree. I didn't even pay attention to that, which, like I said, I'm newly divorced and doing things on my own. And yeah, very interesting. Okay, I didn't see that, but yes, I'll agree upon that.
Understood. Okay. And then you see the damages. It says partial paint and repair walls.
Yes.
Correct. Okay. But I'd like to go back to
Which I do not agree upon that.
plaintiff's exhibit number 2. It says email from handyman.
Yep.
If you review that document,
I
Yeah,
can pull that back up so we can all see it. There we go. I have to zoom in.
Yeah.
Oh, it's as zoomed in as I can get. All right, a moment. Go ahead, sir.
so if we review that document, Ms. Maville, it says on the last days of Shanty, I apologize, that's there, Ms. Maville's residence at the property in question, which I'm assuming is the property that we're leased here. He said he came over and removed some drapery and nails from the pictures she had on the walls. Did not remove nails that were painted over or existing from previous tenant. I don't know how you would know that. But then it says, I wet sanded them so the sandpaper wouldn't mar the walls. So would you agree that Mr. Shore performed work on the walls, correct?
Absolutely. Yes. And the nails you were saying about before that were in there, that's what I'm saying. When I moved in, there were already several different nails and marks on the walls, which we left.
Okay.
And I had my own 3 pictures hung, drapery hung, and I had them repaired
But you didn't take pictures or file any pictures with the court regarding your move-in, correct?
Yes, I didn't file it with the court, but I do have those in there buried in my third phone. I have 3 phones, a Canadian phone, an American phone, so I can submit those if I need to. But yes, I did take pictures of those, and I took pictures of the grout, which I sent into real estate development.
I understand that, ma'am, but you're not being charged for the grout. You're just being charged for the repairs on the walls and the painting and the partial repaint. Is that correct? Do you agree with me on that?
Yes, but
okay, so the grout has nothing to do with this claim.
But you were questioning about the nails being there before, and they were, and my handyman is saying that there were, the apartment was not repainted when I moved in. The apartment was not, there were still nails on the walls. So that's his statement, that's the truth, and that's what's on there.
Okay, so yesterday when I filed the notice of filing, it was a Ramo Remodeling Corps. I don't believe it's hit the court file yet, Judge. I can
not. Tommy,
Yeah.
Do we have?
That was kind of a little surprise.
Tommy, do we?
Because
Have,
I've asked Mr. Zombalis for that several times.
hold on, Tommy. Do we have that document in the queue?
I can check for you. Just give me a moment.
Yes, sir.
Thank you.
We can move on from that, Judge, while the
All right.
clerk is taking care of that. So just so I can understand, it's your position that none of the apartment needed repainted whatsoever, correct?
Absolutely. That's why I took the pictures. The walls were in perfect condition.
Okay, but you agree that those pictures
Just normal wear and tear.
don't indicate really anything? You can't really see any color on the walls. You can't see.
Well, I
was
submitted
painted, what
pictures
wasn't
this
painted.
morning after I got your statement and with the bill, that bill about the paint. I submitted pictures to Sarah and I didn't have time to e-file them because I don't do that. My daughter does that. I don't know how to do that. But I did submit pictures that Sarah would have of colored pictures of, my pictures, not the black and white.
And you didn't copy me on that?
Well, and I gotta be honest with you.
I just did that at 9 o'clock when I turned on my computer and saw that. So I thought maybe I would resubmit these pictures so you could see them better.
All right, because I gotta tell you that Sarah is actually not with me today. She had taken the day off. Everything that I've received by 5:30 p.m. yesterday, I have in front of me, but that's it.
Oh, okay. That was sent this morning because I just got this email from Mr. Carney this morning on the bill and saying that it needed 2 coats. And I'm like, why am I paying for the condo to be repainted? There was no damage. And, if the apartment needed repainting, I would think that would be the company's business and,
All right.
obligation to do, not mine. There's nowhere in the lease that says that I am to repaint the apartment.
All right.
Hey, Adam, are you ready for me yet, Adam? Please.
I'll be right
Please,
for
Adam.
you. Yep, just shortly, Mr. Zorbalis.
There's so many things she said that are incorrect or just completely
Hold on,
contrary to everything we submitted.
Sir.
Understood. Yes.
Hold on a moment. Your attorney is trying this case. He will let me know when he's ready to call you as a witness. Go ahead, Mr. Carney.
I don't have any further questions for the plaintiff, Judge.
All right. All right. Mr. Carney, would you like to call your first witness? Well, actually, before I do, Ms. Mabille, are you done with your case? Was there any other evidence you wanted to show to me?
Just better pictures, which I sent. And like I said, I did not have time to send them in because I just got that email this morning about the bill and the repainting and having to paint the whole apartment, so I sent, like I said, Sarah and my daughter, who is in California and sleeping. And I said, please try to e-file these this morning. I got them at 8:30, 9 o'clock this morning. Okay. So all right. That's the only evidence I would like to resubmit, but I can't.
The color photographs.
Okay.
All right. Let me see if Mr. Carney, if we're going to introduce the document you're talking about, and if so, because that was also filed late, let me see if I can retrieve the color photographs. I'll make sure I have some means of you being able to view them before I would enter them. Okay. But let's go forward with the defense's case. Go ahead, Mr. Carney.
Defense would call Mr. Zorbalis.
All right, Mr. Zorbalis, I need you to go ahead and turn your camera and your mic on for me, please. Thanks, sir. I need your mic on, please.
You please state your name, Mr. Zorbalis.
Mr. Zorbalis, can you hear us?
Spiros.
Sir, can you hear us?
Spiros. Turn your car off.
He might be hooked. He's probably hooked up to the Bluetooth.
Can you hear us?
Oh, I can't wait to get back in the courtroom. No, I've never had somebody drive their car into my courtroom. Although I did have a lady once time bring in a bunch of car parts. Wait a moment.
The tough thing.
Okay.
2 more weeks. 2 more
The
weeks.
21st, 10 days, right?
Yes, sir. 2 more weeks of doing
Well,
this.
we can postpone this for 2 more weeks. I would be happy to do that.
No, ma'am, I don't think I want to do that. I think we're gonna finish things today.
There
All
it
right.
goes. You hear us now, Mr.
I got-
Zorbalis?
I got disconnected. I had to redial in again. I couldn't hear anybody.
Yeah, no,
I think
no
it's-
problem. So we got you now. All
I
right.
guess that
Mr.
fancy
Okay, I got
card-
in. I'm sorry, Your Honor. I'm just sitting here. I'm sorry.
No, you're fine. Mr. Carney, you're gonna call this gentleman as your witness. Go ahead, sir.
Correct. Hey, Mr. Zorbalis, can you state your name for the record, please?
Spiros Zorbalis.
And who are you employed by?
I am employed by RDG, the property management company that manages the unit for the entity that owns the unit, which is Reserve at Naples Condos LLC.
All right. And did Reserve at Naples Condos LLC enter into a lease agreement with Shanty Mobile?
They did.
And would that have been in about like October of 2018?
That's correct.
And that would have ended October 31st, 2019, correct?
Correct.
All right. And that lease agreement has already been previously entered into evidence. And
Well,
did
actually,
RDG
I don't think we actually moved it in. You wanted it entered as defendants 1?
defendants 1, please? And I believe that Ms. Maville didn't object in her testimony.
Correct.
Um,
So Tommy, the lease document, which is looks like 17 or 18 pages, will be admitted as defendants composite 1.
and you'd indicated that RDG had collected a security deposit on behalf of Reserve at Naples Condos LLC.
Correct, for $1,195, and that money was escrowed.
All right. And upon move out, just give me the rundown of what RDG or RDG on behalf of Reserve of Naples LLC does when a tenant moves out of the property.
When one of our tenants moves out of the property, we have a 30-day statutory limit to review the unit, do whatever repairs and maintenance we have to do if we're going to impose a claim, get the receipts from the vendors, and if we're going to impose a claim, make sure it's correct, put it in a written format, and send it certified mail to the tenant, which in this case we did. We did all of that and sent it to this particular tenant.
Okay, so in doing so, you've sent the notice of intent to impose claim on security deposit. That's what you're talking about, the 30-day statutory notice, correct?
Correct. Our office sent the 30-day statutory notice to this tenant, correct.
And what was the plaintiff charged for in that case?
The plaintiff was charged for the $195 administrative fee, which is contractual, which was already talked about, and then was charged for some partial paint to the walls and some repairs that our contractor had to do. We have many units, and for us to be able to manage the statutory time frame, we use 3 contractors actually to paint and repair our units so we can have them done properly and sent back to us in the time frame needed.
So, and in this case, the entire apartment was repainted, correct?
In this case, from the receipt we found back from 2019 that we paid, the entire apartment, yes, the entire apartment was painted.
But only a portion of that entire apartment paint was charged to Ms. Maville, correct?
Correct. Upon looking at our backup and our receipt, not all the painting that was done was charged to the tenant. The manager always walks the unit after the tenant leaves and then walks it after the painting is done to make sure that the proper charges are charged. And because some of the painting was not required under the statute, that it was customary wear and tear, but other was, she went in, walked it, and charged what she felt was appropriate for the repairs that were done.
So when a tenant moves out or moves in and they put nails and drapery rods and other things on a wall and then end up patching the holes and kind of painting over, that'd be like a partial repair for the wall, correct?
Well, it's pretty customary for tenants, and I don't think they're trying to do anything wrong. I think this lady, I don't know her very well, seems very nice, very respectful, but what I don't think they understand, or they underestimated our business, is when you put holes in, for instance, to put up a rod or to put up whatever you put on the wall, that marks the wall. So even if somebody came after the fact, and I believe her that someone came in afterwards, and if they just fill it and then sort of scrape it, which appears what they did, when the apartment is empty and we're showing the apartment, if we don't go in and scrape it all the way down and finish that entire wall, what you see is you see holes everywhere because the paint is of different colors, it's not scraped right, and we can't rent apartments that way. Can you imagine going into a living room that's vacant and on the 3 walls besides the window here, there are round holes everywhere? And I don't mean holes as in damaged holes, but painted holes. It looks horrible. We can't rent apartments that way. So that's part of bringing it back to the way they got it. So when our contractor goes in and has to do that work, they go in and anywhere there have been anything on the wall, they fill it, they scrape it probably 2 feet around, not just the inch or 2 or whatever the hole is, and they finish it. They put a special coat of paint over it, and then when they paint it, they paint the whole wall, and we charge for that. And in this instance, it appears that a number of the walls she was charged for, not all the walls, and the repair was charged for, and it was done that way. Actually, I didn't remember, but I went back and read the notes that were submitted to the court, and our office actually tried in a very professional way to explain to the tenant that this was done. And honestly, if you're not in this business, you might not understand what contractors charge, but you can imagine what it costs now when there's nobody working. It's hard to find people, but it's very expensive to do this work, unfortunately.
So, Mr. Torvalds, I want to bring your attention to the Ramo Remodeling Corp invoice that was noticed of filing yesterday and sent to the plaintiff. Do you recall that document?
Yes.
And on it, it says repair 2 walls. Many areas need to be filled, scraped, and sanded to prep for painting, and that charge was $235, correct?
That's what Ramoyo charged us for the prep work they did, where they knew that there had been stuff on the wall, whether it was the rods or whatever had been put on the wall. So they charged for that separately than the painting.
Might be the other.
And in your
hold on, time out. Ma'am, I will give you an
Yes.
opportunity to present a rebuttal, but in the meantime,
Okay.
I need to hear what this gentleman has to say, all right? Mr. Carney,
Okay.
please proceed.
And in your experience working for RDG and the management company and managing residential units here in Naples, is $235 a reasonable charge for prepping prepping multiple
Yes.
walls for it?
Completely. I mean, we've had charges double or triple that where they have to prep all of the walls. It's just how they charge us.
Okay. And then below that line item on that invoice, which is dated 11/22/2019, it says the entire apartment painted, some areas needed 2 coats. And that unit price, the charge for the whole amount was $1,095. Is that about reasonable and customary in Naples for painting a whole entire apartment?
Just to give you an idea, our range of prices for 1, 2, and 3 bedroom apartments will run from $1,100 up to $1,900. It's very customary. That's what we get charged. We pay it every month, and it's just what it costs us.
And in this case, RDG and Reserve of Naples Condos LLC says that only a portion of that entire apartment was to be charged to the tenant. Is that correct?
Correct. As I stated earlier, after reviewing the painting before and after the tenant moved out, before the work was done and after the work was out, pardon me, the manager decided that some of the work was customary and some of the apartment was fine and was not to be charged per the statute, but some was, and she apportioned it accordingly.
And is RDG or Reserve, who's currently holding the money for the security deposit? Is RDG or Reserve of Naples LLC?
It's in an escrow account for for Reserve of Naples condos, RDG would then write the check. So if we had gotten that form back from the tenant, we would have then taken the money out of the escrow and we wouldn't have written a check to the tenant. That's how we do
Okay.
it all the time.
And presently, the full $1,195 is being held, correct?
Well, since there was a dispute, the money's being held, even though we've paid everybody.
Understood. And by everybody, you mean the contractors, correct?
We've paid the contractor. Yes, we had to, obviously.
Yeah.
We paid them back to almost 2 years ago.
Understood. Is there anything else you want to add, Mr. Zorbalis?
No, I think this is very customary. I think the tenant, like I said, she seems respectful. I don't remember meeting her, but this is very common in our business. And I guess if you haven't rented apartments a long time, it would have been, the work needed to be done, and our receipts support it. And we're not trying to be difficult. And I apologize if a tenant took it wrong. We just,
Okay.
That's it.
Okay.
Mr. Carney, give me 1 second. Tommy, did we get any luck finding that notice of filing from yesterday?
Yes, Your Honor, I docketed it. It's line 58.
Thank you, sir. Let me do a quick refresh, see if it pops up. There it is. All right, so I see the notice of filing. And here is this document from Roymo Remodeling Group. Let me do a screen share. So, Mr. Carney, this is the document that you were referring to, correct?
That's correct, Judge, and I move that into evidence.
All right, Ms. Mavila, any objection to this document being moved into evidence at this time?
No.
All right, and this will be admitted as defendants 2. Is that correct, Mr. Carney?
That's correct, Judge.
All right, print this out.
But I do have some questions on the bill, if I may.
Well, when Mr. Carney is completed, yes, you
Okay.
can.
All right.
So, sir, anything further?
No, Judge.
All right, so Ms. Mavila, you can ask Mr. Zorbalis questions if you wish before you go into your rebuttal case. Do you have any questions for this gentleman?
I'm not sure that I really want to have questions to him or the attorney, but whoever the case involved.
The attorney,
Okay.
But if you don't have, hold on. If you don't have any questions for Mr. Zorbalis, Mr. Carney, do you rest at this time?
Yes, Judge.
All right, then Ms. Mavila, you have a chance to rebut some of the things that you heard at this point, and then I'll make a determination.
Okay. Mine is the repairs from the past tenant. He said that the company that went in had to repair all the holes and all the different marks on the walls. Well, those were there from past tenants, number one. And number two, it said that they had painted the entire apartment, and Mr. Zorbalis is saying no, that I was only charged. So I was charged $1,195 for a second coat of paint. It says that on the bill. I don't get that. Anyway, I think the bill is questionable, and like I said, I don't know why I'm responsible. My deposit is responsible for painting the apartment, which didn't need painting unless he felt that he wanted to paint the apartment. The repairs were already done by my person, and the walls were in livable, decent condition, and that's just my case, I guess.
All right.
So I don't understand the bill at all. It doesn't make sense to me.
Adam, I can answer that on recross.
Well, we're not quite
No.
there. Mr. Carney, did you want to present anything further at this point?
I would. I'd just like to go back to Mr. Zorbalis briefly to address the points that Ms. Mavell brought up.
Fair enough. Go ahead.
Mr. Zorbalis, what do you want to say?
When a tenant moves in and they have damages, we specifically, in our lease, it specifically states that they should get something to us in writing with photos that we put in the folder prior. We have many tenants, for instance, who have sent us a document saying, hey, I moved in, here are my photos, they attach them. We put it in the photo. Even if we've gone in and done the work and they find other damages, like something's loose or the light's not perfect or there's a damage here, and we document it. and we leave it in the folder. So when they move out, whether it's after year 1 or year 10, we go back and we go through the folder. That's part of the process to make sure, just like our manager goes through and looked at the apartment to make sure they only charged what was correct and not was customary or not tended to the tenant is correct. So those damages that she's referring to were not there when she moved in, or they would have been in the folder.
Well, I sent emails and pictures to you and to your office of all of that. So when I first moved in, I was
Why
told,
is she talking?
I'm going to object, Judge, to.
Hold on.
Yeah.
Okay.
All right.
I mean, there's nothing in the folder, Your Honor, with any of that, or it would have been documented, or she would have submitted it to the court, which she has not done.
Okay. Okay. So you do have an attorney who can speak for you.
Okay, I'm sorry, Your Honor.
Okay. But that point is well taken, Ms. McGill. I don't have any proof of that in front of me.
exactly. I didn't know I would need proof of that, but I did take pictures, which I was recommended to do from Mr. Zarbella's secretary, Rosaria. I took pictures coming in. I sent an email with the pictures at the very beginning of moving in. And that's where the grout situation happened. That's where I said there were already nails in the wall. I'm just going to leave them. So that was all documented. So whether that's in the file or not, there's no proof of that. He's he says it's not in the, we don't know. I don't know that that was not. I could dig up my email and find that if I need to, which is probably 2 years ago, but I could find it. But yes, I did do that.
All right. Mr. Carney.
Closing argument, Judge?
Yes, sir.
Thank you. Yeah, just briefly, court heard evidence regarding the lease that was entered into evidence. Further, the court received into evidence a notice of intent to claim security deposit on that was sent November 27th. It's clearly the defendant objects to that notice of intent to claim security deposit, and subsequently the tenant filed suit for $1,200 in this case. The evidence shows that $1,195 was the security deposit. Tenant did in fact pay that. The lease does provide for an administrative processing fee of $195 that tenant is responsible for. It's not a dispute. The lease further provides that the security deposit can be applied against any expense incurred by landlord for damages and or unpaid costs, including touch-up paint and wall repair. The evidence shows before the court that the tenant acknowledges that there was wet sanding of portions of the walls and hanging of draperies and nails on the walls. And further, the evidence shows the defendant's Exhibit 2, the Ramo invoice that there were repairs to the walls. Many areas needed to be filled, scraped and sanded to prep for painting, and the entire apartment was in fact repainted. It's undisputed that the evidence shows that the tenant was only charged partially for the for the repaint for the walls that were required to be repainted. Upon tenant moving out, the landlord inspected the premises and performed the repairs that were necessary and proper for a tenant, for a landlord to perform, under the circumstances. As such, we're requesting the court to dismiss the statement of claim in its entirety, find that the repairs were necessary, and release the $1,195 security deposit to the landlord, Naples Observed Condos, LLC. And further, pursuant to Florida Statute 83.493C, assuming the court does find that the defendant is the prevailing party, award attorney's fees and reasonable attorney fees and costs as well.
All right. Ms. Maville, did you want to say anything further?
Yes, I think my main evidence is my handyman, which I could get a more in-depth statement if I need to, which is what he said he would get a notarized statement, and my pictures, which I thought they were going to be more clear and more specific, but I did send in some pictures, and I can send in some pictures.
Well,
I think I
I'm
still
sorry.
go with my
Let me
claim.
interrupt you real quick. I'm sorry. I did say I would see if I could retrieve those color photographs because Mr. Carney did allow, that the late submission.
I have no objection to your honor reviewing those.
All right, everyone hold tight for one moment. Let me see if I can find those color photographs. If they really are,
Part
give
of the
a better idea.
proof.
Let me take
Yeah.
a look, all right? Give me one moment.
Okay.
I'll be right back.
You're on mute, Judge. There you go.
Here we go. All right. I'm getting the emails forwarded to me right now. And so, Mr. Carney, I can do a screen share and show you the photos.
That'd be fine, Judge.
And then we're printing them out now.
Thank you.
So let's see here. Well, oh, there we go. All right. So let me see if I can do this. Perfect. All right. So this is the first photo. Showing one of the walls. All right, here's the next one. I don't know if you can see this. Okay.
So, Your Honor, on that first photo where there's a little mark, that was a nail that was already originally there and left there. So Mr. Zambales was saying that they repair all the walls and have everything pristine before the client moves in. Well, that's not the case. There's a nail there that was originally there and left there.
Where are you talking about?
And I'm gonna
Handyman would not do that, would not repair that because he said it was already there. And that we
I'm
shouldn't
going to object
touch
to
it.
hearsay on that one, Judge. And I'm going to renew my objection to foundation for all these pictures to come into evidence. There's been no time frame. There's been no testimony that, or there's no argument that these are accurate.
Well, they were sent in originally.
At the time.
Well, I don't know about the time frame, but they were sent in originally with my file. And
well, all right.
We don't know when they were taken. We don't know who took them. We don't know what it shows.
Well,
I don't even know if that's the apartment.
Well, this would be able
They're
to
not.
answer those questions. What are these pictures of? When were they taken? Who took them?
would you like me to answer those questions?
Yes.
Oh, they were taken the day I moved out. They were taken by me and my handyman was there. So I have a witness again. So that's when the pictures were taken, and that is the condo If Mr. Shapiro has any pictures of the condo, of it being painted and of the damages, I would like to see them.
Well,
That's the only proof that I've had to go on. And all I can say.
We've lost Mr. Zorbalis again.
Yeah, he must have logged off or got disconnected. I'd further argue to the court, if the court does enter into evidence, to take the proper weight, given that not every wall has been photographed and shown. And respectfully, the evidence that's in the court file is that Ms. Maville was charged for a partial repaint. Yeah. and other matters. So what she's showing it's a partial picture of the apartment, and the evidence is that only a partial repaint was charged to Ms. Maville.
There's a couple of issues here. The administrative order for these remote proceedings does require that documents be filed no less than 5 days before the proceeding. But I did allow, the receipt from the contractor to be admitted. The foundation objections overruled, so the photographs will be admitted. And Tommy, I think I misnumbered some of these documents because I'm up to 5, not 4.
The emails between Ms. Mayville and RDG are plaintiffs 1. The email from the handyman is plaintiffs 2.
Correct.
The 2 checks are plaintiffs 3.
Yep.
The black and white photographs that are attached to the statement claim are plaintiffs 4. Okay. And then plaintiffs 5 are these color photographs that that Your Honor is admitting into evidence now.
All right, which are basically just the color versions of what was attached to the complaint.
Correct. I think there's a couple more included in these colors.
Yes, so I'll include these as plaintiffs 4 because these are the color versions of what was originally admitted. So, given that, I want to be fair to you, Mr. Carney, Mr. Zorbalis didn't have a chance to see these color photographs. It does leave the question because he testified that there was spotting on the walls that would require that repair, and I'm very familiar with that issue. I'll confess to both of you that in a former life before I was a lawyer, I was a property manager, so I know exactly what he's talking about. But I don't see that in the photographs, and I'd like to give him an opportunity to review the color photographs, which are much more detailed, and respond if you want to try to reach your client and see if because he didn't have a chance to see these and respond.
If I can get on the horn.
It's your call, Mr. Carney, if you want to try to give him that.
I'm trying them right now, Judge.
Yes, sir. Yes, and it very, very, very feels like a long time ago. That's what I used to do for a living.
I wasn't able to reach him, Your Honor, so he was on. He hasn't contacted me, so I can't represent in good faith to try to continue or anything further.
Oh, I understand. So, and I said, let's try it. Looking at these photographs, I don't, like I said, I was a property manager. I used to manage large complexes. Yes, please. Thank you. Thank you very much. I used to manage large complexes with thousands of apartments. And I saw all manners of how people took care of their units. Literally from, absolutely spotless to, no joke, setting the carpets on fire on their way out the door. What I have seen many, many, many times, which is what Mr. Zorbalis was referring to, is a good faith attempt by tenants to try to do the wall repairs themselves, to fill the holes for drapery or pictures or whatnot, fill the holes, sand it, and try to paint it, and it never matches properly. Right? There's a noticeable difference from one white to the next. The apartment manager has a shade usually of beige or white that they use for all their units, and it's impossible to match exactly. You go to Home Depot and buy a can of paint, you never quite get it right, and it's a noticeable different shade. And that's what he's talking about, and it does require a painting of the wall to fix. I had that happen myself personally when I was a tenant. My wife and I tried very hard to leave the unit in the best possible condition, and we spot painted all over the place, and it looked like leopard print. We tried so hard to match the white, we never got it. And so the landlord really did have to paint all the walls. I will say this, the rates being charged by this contractor are not at all unusual. I'm actually surprised that it's not more, given that this is not that different from the rates I used to see when I was a property manager 20 years ago. The only thing that's really kind of hanging me up here is looking at these photographs. I don't see that spotting. Particularly, let me show you, particularly this one spot on the wall here. Because this is where the drapery would be.
I think we're left to assume that, Judge, at this point, regarding the drapery rods, and it's shadowy.
It is. I mean, that's the problem, and that's the problem with the photographs.
And I don't think it's a fair and accurate depiction of, what the walls and the situation was at the time. I think the evidence that we have.
And that's the problem. If you were to take photographs of the walls of many of the units that I've seen as a property manager, it would look fine in a photograph. But when you get up close, you can see those spots. You can see the difference in shades of paint.
Well, the only thing I could say in my defense is my handyman, who's a professional handyman, who's done this forever, made sure that the spots where the nail holes were very tiny, and he covered them properly, and you couldn't see any difference. And that's why I took the pictures. There was no markings on the wall, except for nails that were already there. There was no marking on the walls. The walls and the floors, everything was, immaculate. I even had people come in and clean. My ovens were clean. Everything was done as much as it could be. And I believe it was normal wear and tear. There was nowhere where I saw in my lease or where I was told that I was to paint the apartment or have the, everything up to par. And why, when I moved in, were there still nail holes and marks all over the walls and grout all over the walls, needless to say. So I'm sorry, but I think I'm being overcharged.
Yes, sir, Mr. Carney, go ahead.
No, I just was just going to assume that was all argument, and I wasn't going to object for testimony purposes.
No, it was just argument.
Got it. Thank you.
So I'm not gonna lie, this is a tough call, because like I said, I know to be true everything Mr. Zorvala said about practices about the business. I know to be true the charges were customary and normal for the industry. I know to be true that what he said is a very common occurrence. That's something that property managers have to deal with all the time. The tenants who are acting in good faith still leave it in such a condition that requires that painting. But the evidence that I have, based upon Ms. Mathiel's testimony and the photographs that were submitted, show that I don't see that spotting. It shows a unit that was left in very good condition based upon the withdrawal from the security deposit. And while Mr. Zorales can testify, and I think he did absolutely truthfully and accurately about what is common within his business, and would potentially be an explanation for those charges, that's just not what I'm seeing in the evidence. And he did not have his manager testify today to testify this is what she saw. He is surmising this is the basis of those repairs. And so I find partially in favor of the plaintiff, because what was clear from the lease was that the $195 should be properly deducted from the deposit. And as Mr. Carney accurately stated, the original deposit was only $1,195. It was not $1,200. And so, the
I
correct.
understand the court's going to make his ruling, but I'm going to make my one last push anyway. I mean, the evidence is also in there is that email from Ms. Maville's handyman indicating that there was wet sanding done to the walls, and
Right.
the pictures were not of the whole entire apartment, and we're arguing for a partial application of the full amount of that was painted. So I mean, it's not complete evidence, and I think that
well, I agree, but like I said, I have the testament of Ms. Maville that the walls, that his work was done in such a way that you could not see those spots. And Mr. Zorales didn't personally inspect the unit. He's surmising that this assessment that was done by his manager was based upon these factors, but I have no testimony before the court that says that is in fact the basis of this. I know he has to rely upon his property managers to make accurate assessments, but I don't have any testimony of the person who actually observed those walls. But I do have the testimony of Ms. Maville, who says that her handyman did this and that there was no observable spots that were described by Mr. Zorales. And I said, and what he's talking about, I got to tell you, I saw hundreds and hundreds of times, but that's not what's before the court today. And so I do find in favor of the plaintiff in part for a return of $1,000 of the security deposit. The $195 was appropriately deducted as the administrative fee that was part of the contract. The parties are jointly and severally liable because it does appear that
it will be an issue, Judge, for return.
Yeah, I didn't think it would be, but because we have that two parties, I had to figure out a way to appropriately word the judgment to do that. All right, and that's going to be the judgment of the court this time. Anything further from either party?
Could I have the my partial payment made to the courts? Through the courts to me?
No, ma'am.
No?
No, we don't touch people's money. Not for that purpose. You'll have a judgment. You'll have a judgment issued stating that Real Estate Development Group and the Reserve at Naples Condos LLC, a judgment in the amount of $1,000 is payable to you. And I imagine Mr. Carney will make arrangements for that.
Okay.
Pass it on to the client. And Ms. Maville, could we just get on the record for her to mail the check?
That's a good idea.
For that, because you've been moving around and I'm not able to call you per one of your emails.
Okay, my address is the 165 Bristol Lane B, Naples, Florida.
Wait, 165 Bristol, Bristol Lane B.
And that's also on my document.
Yeah, there's a lot
There's
of
two
different
addresses, and the recent one, the most current one is that one, Bristol Lane B, Naples, Florida, 34112, I believe. I mean,
Okay. Okay, we'll notify my client.
All right. All right. Thank you, everybody.
thank you, Your Honor.
All right, take care. Thank you.
Thank you. Have a good weekend, everyone.
You too.
All right, Tommy, did you need something?
Nope, I'm good.